Some of the acts, as I mentioned earlier, could be wage fixing, i.e., a bunch of HR people sitting together, or a bunch of commercial people sitting together and say, hey, let's fix the wage for this particular level of people to be this. But that is not actually the most risky, because I don't think people actually in practice do that a lot. The most risky is what most HR people would do, is to actually speak to each other and find out about what their company actually does. The problem is the guidelines issued by the Commission had actually quite clearly set out that if the different companies, i.e. the undertakings, actually sit around and have an agreement that we would increase the amount of salary to a certain percentage, or we will provide certain benefits, or even exchange of that information, not necessarily having an agreement of that sort, could potentially be a concerted practice, which means that could contravene the competition law. However, a lot of people say, wow, does that mean that I can't actually speak to each other? Because this is, a reality, we do speak to each other. Now, I personally believe that you have to be very careful, because it really depends on the nature of the information that you're exchanging. Obviously, if you're exchanging very, very high-level sensitive information, that is more likely to be in contravention of the law, because if the people that receive that information actually uses that information or intends to use that information to make their decision, then that would likely affect competition. But if, for example, people just sit around to talk about certain minor fringe benefits, exchange information about what they think, or historical data, or if they tell people I did that last year or the year before, or my previous experience was this, then personally I think it's unlikely that is going to be an issue. However, I do need to put a disclaimer in at the moment, is because at the moment, as I said, the law is very fresh. We haven't got much case law. We've only got the guidelines. The guidelines are quite strict, and so we don't know whether or not certain practices could potentially contravene the law. So people need to have a very good judgment as to what is important, what is likely going to affect competition. It is probably prudent to think twice before exchanging information.